Hi guys, welcome to De Jure. This is part 2 of Labor Law Important MCQs. Let's get started. Question number 1. The minimum rate of subsistence allowance in case of suspension pending inquiry has been given under which of the following legislations? So this has been given under Industrial Employment Standing Orders. That is answer C. Next, which of the following statements is not true regarding Industrial Employment Standing Orders Act 1946? Again, the answer is C. There is no provision to refer the draft standing orders to union workmen by the certifying officer. Next question. Drafting the standing orders are to be submitted within. Again, the answer would be C. 6 months from the date on which the act is applicable. For 5 copies they have to be submitted. Okay. Next question. Which act requires employers in industrial establishments to define the conditions of employment? The answer to this is contained in the Industrial Employment Standing Orders Act 1946. Next question. The Industrial Employment Standing Order Act 1946 applies to every establishment employing, the answer would be 100 workmen on any day preceding 12 months, and the government can order by application to establishment employing less than 100 workmen. Next question. The provision relating to suspension has been made under which of the following legislations? So this has been named under Industrial Employment Standing Orders Act, obviously. Next question. Which of the following amendments of the Industrial Employment Standing Order Act provided for payment of subsistence allowance by the employer to a suspended employee pending inquiry against him? The answer to this is Industrial Employment Standing Order Amendment that was done in 1982. Next question. Arrange the following steps of disciplinary procedure in the order in which they are used. First would be show cause notice, then there would be serving of the charge sheet, then domestic inquiry, and after that submission of the report codes, and at last it would be dismissal and discharge. So the answer would be A. Next question. The copies of the certified standing orders authenticated in the prescribed manner may be sent to the employer, the trade union, or other prescribed representatives of the workmen by certifying officer within 7 days. So it could be sent to any of them. So the answer would be D, all of the above. Next question. The appeal on the certified standing orders may be preferred within how many days? Answer to this would be 30 days. Next question. Standing orders shall, unless an appeal is preferred under section 6, come into operation on the expiry of how many days from the date on which authenticated copies are sent under subsection 3 of section 5. This is important. The answer would be how many days? It would be 30 days again. Next question. A copy of all standing orders as finally certified under this act shall be filled by the certifying officer in a register in the prescribed form maintained for the purpose, and the certifying officer shall furnish a copy thereof to any person applying on the payment of the prescribed fee. Standing orders finally certified under this act shall not be liable to modification except on agreement between the employer and the workmen until the expiry of 6 months is the answer from the date on which the standing orders or the last modifications thereof come into operation. So answer would be A. Next question, number 14. If any workman is suspended by the employer shall pay to such workman subsistence allowance at the rate of how much percent of the wages which the workman was entitled to immediately preceding the date of such suspension for the first 90 days of the suspension. Answer to this would be 50%. Next question. If an employer who fails to submit draft standing orders as required by Section 3 or who modifies his standing orders otherwise other than in accordance with Section 10 shall be punishable with how much fine? So the fine in this case would be 5,000 rupees. That is option C. Next question. An employer who does any act in contravention of the standing orders finally certified under this act for his industrial establishment shall be punishable with fine which may extend up to dash rupees, and in the case of a continuing offence with a further fine which may extend up to dash rupees for every day after the first during which the offence continues. So the answer would be first would be 100 bucks and then subsequently it would be 25 rupees respectively. Next, no prosecution for an offence punishable under which section shall be instituted except with the previous sanction of the appropriate government. It would be section 13. Next, no court inferior to that of which court shall try any offence under section 13. This is again in relation to section 13 as the previous one. Answer in this would be judicial magistrate of the second class. Next question. If any question arises on the application or interpretation of a standing order certified under this act, any employer or workman or a trade union or other representative body of the workman may refer the question to any one of the above. Which one? They can refer the question to judicial magistrate of the second class. Next question. This is also the last question. Five more important questions of this Standing Orders Act was given in my previous video. So you can go and check them out as well. The last question for this video is, who have the power to exempt conditionally or unconditionally any industrial establishment or class of industrial establishment from all or any of the provisions of this act? So who has this authority? It is with the appropriate government by notification in the official gazette. That's it for now. Stay tuned for the next video on labor law MCQs. Thank you for watching De Jure.